And so our hope is afterwards, we will put this recording up on YouTube so we can share it so that if you're working with any groups of people with disabilities who have questions about Proposition 1, you should be able to share the YouTube video with them, and hopefully they'll get their question answered. So I know most of the folks on this call are likely involved with sharing voter information already, but I'm just going to share some voting information anyway. So at BCID, we've been talking to communities of people with disabilities about making a plan to vote. In New York this year, there are three ways to vote. One is voting by mail or with an absentee ballot. The other is by voting early, and the other is by voting on election day. For people who are voting by mail or by absentee ballot, it is currently too late to request an absentee ballot. But if you have an absentee ballot, you can still fill it out or make a plan to fill it out and to make sure it gets in the mail before election day or is dropped off before election day. If you're planning to vote early voting has started as of last Saturday and will go through Sunday before the election. Your early voting poll site may be different from your election day poll site, so please look it up and make a plan to get there. If you are planning on voting on election day, you can also look up your poll site, which will be different than your early voting site. If you need help making a plan, you can reach out to staff at BCID and we'll help talk to you. We're also reminding folks that support staff are obligated to support you in voting. Support staff can also help you in the voting booth, that they may be asked to sign a document saying that they are not your employer or your union boss. We're also letting people know that if you need support voting because of your disability, poll sites in New York have ballot marking devices that you can ask for that have a number of accessibility features. We encourage people to ask for and use those devices, both for yourself, but also so poll staff have good experience using and supporting people who use ballot marking devices. So as I said earlier, I know folks on this call in particular already have a lot of this information, but we want to make sure that we're sharing it. Also, if you know communities who still need voting info, BCID is happy to send folks to go talk to people. BCID is also doing calls, and we can have some of our staff call and help walk people through making a plan or answering questions about voting. But with that, I am going to turn it over to Bobby Hodgson. Bobby is, I believe, Assistant Legal Director for the NYCLU, which is part of a coalition that is helping New Yorkers get information about Proposition 1, which is on the ballot. We'll just say, we've had a lot of questions about this, and particularly today, we'd love to hear about how this affects all New Yorkers, but in particular, New Yorkers with disabilities. So we're going to turn it over to Bobby, and after he shares, we'll just open up for questions and answers and discussion. But thank you, Bobby, for being here, and I'm going to spotlight you, but feel free to go ahead.
Great. Thank you so much, Evan. Thank you everyone for being here and for being interested in Prop 1 and in getting some more information about it. So I am very eager to get to folks' specific questions and to answer them. But I thought what I'd start by doing, and anyone should feel free to pop in with questions in the chat or to raise your hand or to ask me questions as I go if something's not clear. But what I do intend to go through affirmatively at the start is just to answer a few basic questions about, what exactly is Prop 1, the Equal Rights Amendment? What does it do? And as Evan said, I'll give a little bit of background about the context in which it came about, why it's happening now, why it is on our ballot, here in 2024. And then segue into the specific, expected effects this will have on the rights of people with disabilities, in addition to the rights of all New Yorkers. So, starting with the first question, just basically, what is it? What are you going to see when you flip your ballot and look on the back of it, and see the question, do you vote yes or no on Proposition 1? So what it does is it amends a provision of our New York State Constitution, Article 1, Section 11, which is where you find our state's Equal Protection Clause and Civil Rights Clause. These things, are very much parallels to the Equal Protection Clause that exists in our United States Constitution, but they're part of a whole separate document, and New York has its own set of constitutional protections. The Equal Protection Clause of the New York State Constitution was passed and entered our Constitution's language back in the 1930s. And at the time, it was a really important addition to ensure that the rights of New Yorkers in certain contexts were vindicated. But it definitely reflected sort of the limited scope of civil rights at the time in the 1930s. So it says very specifically that, no person shall, because of race, color, creed, or religion, be subjected to any discrimination in his or her civil rights. That's the current version of New York State's Civil Rights Clause in our Constitution. Obviously, since the 1930s, our civil rights laws have caught up quite a bit and added additional protected categories to ensure that people aren't discriminated against on the basis of a host of other characteristics that have unfortunately historically, been targets of discrimination from government actors, from other private actors, from employers, et cetera. So starting in the 1960s, we've had a series of laws, of statutes, including New York State's human rights law and civil rights law, that has had an expanding set of protected categories that recognizes that not only is racial discrimination or discrimination on the basis of religion prohibited, but also discrimination on the basis of sex, on the basis of sexual orientation and gender identity, on the basis of age, and on the basis of disability. That type of discrimination is also prohibited under New York State's laws. So the first thing that the Equal Rights Amendment will do is sort of harmonize our constitutional language with the network of state laws that we already have. It will make sure that when we say civil rights, like what does it mean for New Yorkers to have civil rights? We're talking about the same protected categories that exist in our state statutes. And why is it important for that to be in the Constitution as opposed to in these laws? The Constitution is just a tougher document. It's harder to change. It takes a 2-year process and a ballot initiative. And it also binds our lawmakers and our government actors. At any point, a majority of the New York State legislature with the signature of the governor can get rid of a state law, can amend it, can change it, can roll back protections, can create carve-outs that are really harmful to people. But it's very difficult to roll back or change constitutional protections. So adding the same protected categories that exist in our state laws to the Constitution means that future legislatures and future governors aren't able to claw those back, get rid of those protections, or significantly weaken them. It would make it very difficult for them to do so. So the main effect of the ERA is sort of a defensive one, right? It says New York right now has a pretty robust set of protections under our anti-discrimination laws, but we want to make sure that that doesn't change in the future. It recognizes sort of the national landscape that we are in, where rights are under attack in a lot of ways, and where federal courts interpreting our federal laws and our federal constitution have unfortunately been narrowing them quite significantly. So this segues a little bit into sort of the specific context of the ERA as we know it. This didn't plop out of nowhere, right? In 2022, the Supreme Court overturned Roe versus Wade in June of 2022. And in response to that, the New York State Legislature called a special session. It's usually out of session after the beginning of June for about half a year. And this was a special session to address the effect of Dobbs, which is the case that overturned Roe versus Wade, and also cast doubt on a lot of different, constitutional protections that we have come to rely on across the nation in a federal level. Um, and in response to that, New York state legislators um, passed the first version of the Equal Rights Amendment, which was to become Prop 1. Um, they did it, in such a speedy way because in order to get on the ballot and in order to amend the Constitution, something needs to be passed by two successive legislatures, and only then does it go on the ballot. So they started the ball rolling in the summer of 2022. The legislature had to pass the same version of it in 2023, and that is why it is currently on the ballot here in 2024. And so it is, obviously central to a lot of the things you're going to be hearing or you have heard about the ERA, which is that it enshrines the right to abortion and to reproductive autonomy in our Constitution as an explicit aspect of sex equality, of a prohibition on sex discrimination. So that is very much a response to, the Dobbs decision and the rollback of Roe versus Wade. And it's something that was, central to what the legislature had in mind when it passed this. But what's great about it and what's really important is that, advocates for a very long time had been anticipating the opportunity to amend our Constitution in this way and wanted to ensure that if something like this happened, if Roe versus Wade was overturned, or if our federal Supreme Court and our federal Constitution was being interpreted in these increasingly narrow ways, we had the opportunity to address intersectional forms of discrimination and to recognize that in New York State, we want to make sure to protect people's equality based on all of the protected characteristics that recognize a history of discrimination against people that folks have faced for many decades here in New York. And so instead of being a constitutional amendment that only mentions abortion, it is a constitutional amendment that enshrines equal rights across the board into our New York State Constitution. Um, that makes it really powerful. That means that it recognizes the ways in which discrimination can affect people across multiple aspects of their identity, the way in which discrimination and invidious discrimination has manifested in New York across a bunch of different identities. And it attempts to address that all in one go. I think I would also, be remiss if I didn't say that that also makes it, more vulnerable to attack, right? I'm sure folks have seen some of the misinformation and some of the opposition campaign trying to characterize Proposition 1 and Equal Rights Amendment in ways that either, vilify or demonize certain people who are protected by it. I'm not going to, spend too much time talking about that other than to reiterate, a lot of what you're hearing out there is misinformation because, as I said, what the ERA does, what Prop 1 does in the short term, is really just harmonizes our Constitution with the protections that largely already exist in our state laws. It's not changing the status quo in many different contexts. It's mostly just making sure that our Constitution reflects the same protections that our laws already protect. And then looking ahead makes sure that future legislators don't roll those back. I think, the one other thing I'll point out about sort of the text of it and what it does more broadly before I go into its impact in particular on disability rights is there's also a second paragraph to it. So in addition to just adding to the protected categories that exist, there is a second paragraph that recognizes that there are histories of discrimination and efforts to address those histories of discrimination and to correct them should not be considered discriminatory. You might read this language and wonder what it's getting at, but the basic context is on the federal level, again, our Supreme Court has been doing a lot to sort of narrow states' rights and ability to address discrimination. And one of the ways it does that is by characterizing any attempt that takes into account a person's protected characteristic, whether it be their disability or their race or their gender, to address the specific discrimination that affects that group the Supreme Court will often characterize any such attempt that isn't sort of race blind or sex blind or disability blind, right, as discriminatory itself. Um, we could have a whole nother hour talking about this aspect of the New York State Equal Rights Amendment. But what it does is it makes it very clear what the legislators intended to do here and what the people intend to do by passing this is to broaden protections and not to encourage any sort of narrow reading that allows people to weaponize these protections to try and strike down efforts to address discrimination. So that's a lot, but that is the broad impact of the ERA and Prop 1. In terms of how it will affect the rights of people with disabilities, I think I wanted to read a specific, portion of the sponsors memo. This is the legislators who sponsored this, putting this on the ballot and came up with the text of it, went into some detail about what they intended by this. And a lot of it mirrors sort of what I just discussed, the idea that it wanted to harmonize our idea of civil rights and bring it up to the modern day. But it does speak at length about making sure to protect people with disabilities, both in a way that is consistent with our law, our existing statutes, but I think also indicates a more robust and even more ambitious version of what equality can look like. Because it says stuff that doesn't appear anywhere in the text of our laws. Specifically, the sponsors memo says no person because of disability should be subjected to any discrimination, including but not limited to actions which prevent them exercising their right to live in the community, to lead an independent life, and to be free from institutionalization. Discrimination with respect to, for instance, disability or pregnancy would include the failure to provide reasonable accommodations. So this is language that I think gets, a little bit to the heart at what the ERA can do when courts of the future interpret it. And some of the ambitious thinking that advocates and civil rights advocates, in particular the folks we work with who focus very much on disability rights, are excited about in terms of what Prop 1 could mean. Having this right written into our Constitution, being able to enforce it in court when government actors are discriminating against you, adds another sort of tool in the tool belt of an advocate, a person who's advocating for themselves, lawyers who are trying to sort of move the ball in terms of public policy and law. And it offers an opportunity to have an even more robust conceptualization of what equality looks like and how we prevent discrimination. So, what we talk about when we talk with our colleagues who are out there litigating examples of discrimination in the community, particularly, disability discrimination, we talk sometimes about the limits of our federal ADA, right, the Americans with Disability Act, the ways in which in the text of it, they carve out both into the definition of what a covered disability is, and in terms of the remedies that are available to people. They do, there are ways in which that law, that federal law, is unfortunately narrowed and creates challenges when you're trying to vindicate your rights. One example that's come up on behalf of people we represent, they have in the federal text of the statute defined disability to exclude people whose disability in any way implicates substance use disorder. There are ways in which people who are transgender and have gender dysphoria and need reasonable accommodations for that have been excluded from the federal law. There are ways in which specific types of accommodations under the federal statute have been found not to be reasonable. Those types of limitations in federal interpretations and in federal statutory language are not present in this. This language just says you cannot discriminate on the basis of disability. And for that reason, I think folks feel optimistic that state courts interpreting our state constitution will recognize that by passing this, we meant to create a more robust set of protections than the federal statutory scheme that exists and the federal scheme that exists under our Constitution. And in particular, issues affecting folks facing institutionalization, folks facing discrimination that prevents them from exercising their right to live in the community and to lead an independent life. These are specific aspects of this discrimination that the drafters of the ERA intended to address, and that courts will hopefully look to when they're interpreting, cases that they're seeking to expand our rights. So I think I've talked for quite some time. That's I'm interested to hear if folks have any questions about what I said, about some of the specific ways in which I think people are hopeful that Prop 1 will expand people's rights. And then, of course, about the main thrust of the ERA, which is to defend against future attempts to draw back those rights.
Thank you so much, Bobby. And we'll open it up for questions or comments or discussion. I have a few of my own, but I'd like to open it up to other folks first. So, we have a small group, so you could either just take yourself off mute, or if you'd like to raise your hand, I can call on you. But any questions? Okay, so since I don't see any hands yet, I'll start off with one of my own. So people with disabilities have some civil rights protections through federal law, as you mentioned, the Americans with Disabilities Act. Also in New York City has its own human rights law. And then there's other protections like court decisions, like the Olmstead decision, which protects the rights of people with disabilities to receive services and supports in the community.
Mhm.
So how would this proposition interact with people's already existing protections? Would it improve people's protections? Would people have stronger protections under this amendment? If you could just talk a bit about those different levels?
Yeah. I think some of the answer is obviously we don't know yet until courts start interpreting it. But every indication and the way that it is written creates a very clear, number one, there's no way in which it will lessen anyone's protections, right? This is an additive thing that adds, like I said, sort of thinking of it as a new tool in the tool belt. It's a different thing you can cite in your court papers when you're saying I am making a claim under the ADA, the federal constitution, our state laws, our city laws, and now you can also say the state constitution. And I think for a couple different reasons, you should expect this to expand people's rights. And the reasons we think that and we feel pretty confident about that is, number one, the way in which discrimination is listed alongside other protected categories, sort of without qualification and without any sort of the limiting language that exists in a lot of statutory protections, right? When our statutes address discrimination, there are entire sections that sort of go into detail and say, well, we define it in this way. We ensure that you are entitled to a reasonable accommodation. We don't consider this to be a reasonable accommodation. We do consider this to be a reasonable accommodation. We define disability in this particular way. Because our Constitution, in just for a very straightforward way, says you cannot be discriminated against on the basis of your disability without such qualification and without any limiting language, courts would look to the fact that there is that distinction, right? They would contrast it with laws that are more specific, with laws that include limitations, and say, well, that indicates that the people who passed it and the people who drafted it intended to have a more expansive interpretation of what disability discrimination looks like than exists under these other laws. So we would have a strong argument to say, well, federal courts have interpreted protections to unfortunately be limited in X, Y, and Z ways in terms of what you're entitled to, in terms of a reasonable accommodation that is found to be reasonable. And every indication is that when comparing, the new New York State Constitution post Prop 1 and whatever protection and history of case law that they're looking at, they would say, well, this was intended to be a broader application of anti-discrimination protections, and we will interpret it as such. And there's already a history of that happening when they compare, for example, New York City's human rights law versus the states versus the federal ones. Courts are already in the business of doing this and sort of looking at them and saying, well, this one creates a floor. That's the federal constitution. The federal ADA brings it up here. New York state law is a little bit higher because it doesn't have so many exceptions. New York City law is even higher because it says it is intended to be, interpreted in a more robust way. And we would anticipate that the state constitution, because it is without qualification, and it includes such strong language in the sponsor's memo, we would anticipate that courts would again sort of say, well, we think it brings the floor up even higher. And we would make those arguments pretty aggressively in court. I see there's a hand. It's from Nicholas.
Yeah, it's Nico. Go ahead.
Hello. Yes, thank you so much, Bobby, for your presentation. It was really, really informative, answered a lot of my questions that I had. I guess you kind of just answered it a little bit, but I'm just going to ask it again. But was there any specific thought going into not specifying in the language of the amendment about what constitutes a disability, what constitutes a accommodation in a really broad sense? Because I know that this might not be an issue for New York City because our statute is really is the broadest of them all in terms of the state and the federal. But was there any worry that potentially if this was used and raised in the court that they would use I don't know, whatever was decided on before that at a state level or a federal level when thinking about okay, what constitutes a disability under the Constitution? Since it's not specified, we're going to use the ADA or we're going to use the state.
Yeah, that's a fantastic question. I think, it's definitely something that folks thought about. And I think this language was developed in coalition with folks who work across the board in anti-discrimination law, including folks who are litigating and advocating specifically on issues affecting sort of disability rights law, both organizationally and sort of across the country. I think the thinking behind it is twofold. One is none of these categories are defined, if you'll see. And part of that is for simplicity. When you're changing a constitution, it might not be changed for another 100 years. You tend not to include the type of longer text that you would see in a statute that can be changed tomorrow or changed next year or updated as definitions change, as medical understanding changes, as societal understanding changes. So it has to do a pretty robust job of sort of being straightforward, basic language. And the thinking behind.
Thank you.
Oh, sorry. Sure. And I think the thinking behind it, on the second part of the twofold sort of thinking, is that it is clearly adding new protections to our state constitution in a way that makes it clear our state constitution goes beyond the federal constitution. Federal constitutional protections, particularly in the world of disability discrimination, you start to get into questions of what sort of scrutiny do courts apply to a discriminatory policy. And the case law on disability discrimination in particular, unfortunately, doesn't create the most robust version of scrutiny. It doesn't create strict scrutiny. It creates, depending on the type of discrimination, something lower than that. So the idea behind the ERA was to name protected categories that will trigger strict scrutiny in every context and will create sort of the highest level and the most robust level of review. And every indication and every hope is that means this will be interpreted to raise that floor up even higher than, for example, the New York City human rights law or the existing state and federal laws. That was a long-winded answer. I'm sorry. The answer is everybody thinks it's going to move up. We will see what the courts have to say about it, and we're very eager to present our arguments when we have a chance to do this in practice. But that's something that the courts will ultimately sort of decide, and then that will become the case law. And that's why everybody was really interested in creating a long legislative history where the sponsors memo and everybody who's talking about it when they're debating it on the legislative floor and talking about it publicly talks about this as a robust expansion of rights and a protection of rights that's to be interpreted broadly. So it's the best folks could do without making a 20-page, amendment. I see another hand.
Hi, this is Joe Rappaport. I'm the executive director at BCID. A couple of things that I think are useful for people to know. One of which is that we had a role in the language of the memo. There was some dispute between some folks who were interested in other disability advocates. So we sort of played a outreach role and made sure that everybody was in agreement. And the specific thing that's really crucial that is in the language now is about living independently in the community. And that was what one of our colleagues was very concerned about, making sure that was in. And that is, something that we were able to help make happen. A couple of other things very quickly. These kind of expansive descriptions or laws can make a huge difference. So some of us here are very familiar with our lawsuits on subway accessibility, and that was we couldn't bring that under the ADA for a number of reasons, but the basis of the case, or at least the state case, was that the MTA was violating New York City human rights law, which is more expansive than the ADA, which has certain restrictions and so on. So another expansion statewide could be very, very useful. And so that's one of the reasons that BCID and the New York Association on Independent Living actually do support Proposition 1. So just to make it clear that we are hoping that it passes, and because it would make it could be very useful in some of our litigation, and in a better world actually make it so that we avoid litigation and state entities and other entities recognize the rights of people to live independently. I could go on, but I'm going to let Kathy ask or make her statement or ask her question. Go ahead, Kathy.
I'm sorry about the background noise, but thank you for doing this presentation tonight. And I'm just wondering, what can we do now at this late stage? Because I'm seeing all these, ads that are totally, I hate to say it, lies. I know everybody says misinformation, but let's call it what it is. It's a lie. So I know I just posted on my Facebook page the New York City Bar Association's statement as to what it does and what it does not do. I think maybe that's one thing we can all do here. I mean, I don't have money to do an ad or anything, and what has been done, I haven't seen any ads, in support of it. What's happening there, if you know anything about that? Thank you.
Yeah, that's thank you, Kathy. I appreciate it. And thank you, Joe, for your statement before. I think that was really illuminating and helpful. So number one, what can you do? I think number one is just tell everybody you know. I think part of the battle is, when this issue is pulled, for example, when people say, when people have Prop 1 explained to them and are asked across New York State if they support it, it's something like 69% who have said, yes, they do. The problem is not everyone by a long shot knows about it. Unfortunately, there was a whole separate battle that I'm happy to talk about, but I don't think I need to, about the explanatory language on the ballot itself. We think it's inadequate. We think it is not consistent with the sort of plain language requirement of our laws. And that unfortunately, it just sort of repeats the language of the amendment itself in a way that might not let people know what it does, particularly around abortion rights and particularly around the ways in which it protects LGBT people. Because as it currently, exists, it does not say the word abortion. It says reproductive health care and autonomy, and pregnancy outcomes. There are important legal reasons why that was, sort of the drafting language. But unfortunately, there is not a plain language description that says, this is an amendment that would add anti-discrimination protections for all of us. In particular, it would protect abortion, it would protect LGBTQ people, it would protect against discrimination on the basis of disability, et cetera.
Would it
So,
also protect people's right to contraceptives too, correct?
yes. So that again, that's part of
Yeah, I
the
think that's
reason
really
the
important,
language.
but it's not just a woman's issue, it's a man's issue too.
Oh, 100%. Reproductive health care and autonomy is a really broad way to conceptualize protections in this way. And so it would be really, really meaningful for New York to have that and to prevent future legislatures, if political winds change, from rolling those types of access rights back. So the first thing to do is literally just tell everyone in New York, blast out a short and sweet explanation that Prop 1 is on the ballot. If you support it, if you think people should vote for it, certainly explain, I'm voting, here's why I'm voting yes. It'll affect, I think I have found it meaningful to explain the ways, to my friends and family members, how it will protect us, how it will protect them, how it will protect people we love. I think it's really helpful that it expands protection so broadly because hopefully everyone can sort of see the ways in which those that they are closest to are, affected by it directly. So making personal, doing personal outreach is one way to do it. Sharing concise summaries like the one you mentioned, Kathy. I think the New York City Bar, like this is what it will do, this is what it will not do, is a helpful way to combat people
Right.
who
I
may have
just put that.
seen,
I put that in the
thank
chat.
you,
So
some of these ads. And let's like to be specific, you're seeing ads that are suggesting that passing Prop 1 will end girls' sports and allow third graders to get sex change surgeries in schools without their parents' consent. This is obviously, these are lies. This is sort of a really targeted vilification of trans young people that we have seen around the country in a lot of ways. It's helpful to have a resource like what Kathy put in the links to say, number one, absolutely not. This does not do such things. Number two, these protections already exist in New York, particularly with respect to LGBT people. And so passing this will not sort of change the status quo in the immediate term on some of these issues. And then point out that what it does do is protect all of us, ensure that abortion rights are robustly protected. I think, Kathy, in terms of the most potent message, it is very clear that abortion is a very high profile one in the state right now and in the country. And so letting folks know that this amendment does in fact protect reproductive rights goes a long way.
I think that,
Yes.
I mean, abortion is an issue where there's a lot of, either you're for or you're against it. But contraceptives, I mean, maybe more people are like, hey, I've used contraceptives when I, was younger, and why can't other people? I mean, I think that's more, less divisive. So
Mhm.
maybe that might be a better thing to go for because you don't want to have people say no, have that knee-jerk
Yeah.
reaction. I
I mean,
really,
totally fair. Yeah. I think, but the
and
folks
that
you're
about,
talking
and
about.
disability rights, you're going to argue that people with disabilities don't have equal rights to everybody else. I mean, you're going to look at somebody and say that.
I think, yeah, I think targeting your outreach and your message to folks who um, who and what they care about, I think is a really important way to spread the word. I'll share some resources that New Yorkers for Equal Rights, which is the ballot initiative committee that supports Prop 1, have created. I think folks can use them and sort of adapt them in terms of, their frequently asked questions, there
Do
are
they have
short
a
and sweet
fund?
talking points. Sorry, go on.
I'm sorry to interrupt, but do they have a fund that you can like give money to for them to do ads? Or, I mean, I know it's
Yeah.
late in the game, but maybe if they got a little bit more money, they would do another, another day of ads or something. I just was wondering.
There's a donate button at the very front of that. If you click on that link, it's the first thing you see. Um, and I can show you're right. So they put out ads, they have a campaign, but it is unfortunately the case that opponents of Prop 1 have raised a significant amount, or at least put in a significant amount more money, and have put a lot of it into a lot of these ads that are trying to saturate the airwaves and present some misinformation, lies, whatever you want to call it. So combating that has been really important, and spreading, the truth about what Prop 1 does is an effective tool to combat it. Money is also helpful.
So I'll just add a few things about outreach, both for people on this call and also
Yeah.
people watching on YouTube later. So BCID is doing calls to people in our database who have interacted with BCID. Our staff has been doing those calls this week, including Liz, who's on this call. And I were just talking before this about some calls that she did. And in those calls, we are sharing that BCID, Brooklyn Center for Independence of the Disabled, as well as the New York Association of Independent Living, supports Proposition 1. If other people on this call or watching on YouTube would like to be involved with volunteering with BCID to make calls, you can reach out to myself, Evan Yankee, and I'm dropping my email in the chat. And if you're watching on YouTube, it will be in the video description. And I can set you up with a script and a call list, and we can do that. When I've been talking to people about Proposition 1, I've been sharing the New Yorkers for Equal Rights webpage, and there's a list of all of the organizations who support Proposition 1. And so a lot of the times people will recognize those organizations, and it will be an organization they trust, whether that's a union or a civil rights organization. And that's been, I think, a good way to share. But definitely, if people want to get more involved in making calls, we will set you up with a script, with a list of names. And our callers so far have had pretty good experiences with that.
And this is very much when people are making their decisions. I think it is shocking the amount, you can rely on the fact that up until a few weeks before the election, folks have no idea about ballot initiatives and propositions. And this is the moment they are getting their information. And so I've been part of those phone banking efforts, and it's really rewarding. You're really telling people who have no idea about this and giving them the tools to make their decision and hopefully, spread the word about voting yes. And so it is an effective time to be doing that.
Kathy, do you have another question?
Yeah, I just have a quick question. If you do you know where, because I just like open their link, but where on the link where they have the list of organizations and support so that like I could put that in a copy and put it in my Facebook page? I mean, not
Yes.
that I have millions of followers.
No,
It's
it's
a
perfect.
start.
I'll drop it in the link before this is over.
Thanks, I appreciate it.
So Bobby, I have one more question about maybe some specifics. One of the issues that we've been talking a lot about at BCID is in Nassau County, there's been a mask ban that we have opposed because we feel like it discriminates against people with disabilities, that banning masks put people with disabilities at risk. We also know the NYCLU has opposed that. Similarly, Nassau County passed a ban on transgender students in sports, which is another example of one part of the state discriminating against a certain class of people that the other parts of the state disagree with. So, can you talk a bit specifically about how you hope the proposition would impact instances like that, where one part
Yeah.
of the state is trying to do some sort of discriminatory legislation or legislation that people feel is discriminating against a class of people?
Absolutely. I'll start with the second part. So NASA's ban on transgender women and girls playing sports. We at the NYCLU actually we represent a plaintiff which is an inclusive women's roller derby team that is challenging that ban in state court. We already got it struck down once a few months ago. They put it back in place. We're back in court making the same arguments. I would stress, and I know that this is, that number one, this is already illegal. What Nassau County did there is completely already illegal under our state law. It is very clear. The Attorney General's office has written them, cease and desist letters. And we have gone into court, gotten it struck down once. We're very, optimistic that it will be struck down very soon, and that we don't even need Prop 1 to ensure that that is the case. That said, of course, yes, Proposition 1 and the ERA will ensure and harmonize that our Constitution reflects the values that are already in place in our state statutes. In terms of the mask ban, in terms of other times when a local government is trying to pass, whether it be a local executive order or a local law that targets people on the basis of a protected characteristic, the ERA will absolutely provide an avenue for folks to go into court and get that struck down. A local municipal law cannot conflict with New York State's Constitution. And so if something is discriminatory and can be shown that it discriminates or has a discriminatory effect on people with disabilities, on any other protected category, then the ERA is an effective tool to get that struck down. We have a lot of other effective tools to go after, for example, Nassau's mask ban, other attempts to impose regulations that disproportionately affect and discriminatorily affect people with disabilities. But the ERA would be another tool in the tool belt, make it very clear that municipalities, cannot go outside the bounds of the Constitution. I will point out, that's a nice segue to the point that, our current existing human rights laws are wonderful and very robust here in New York compared to a lot of places around the country. That said, as written, there are ways in which it can be hard to access justice under them. There's a little bit of play in the joints because they are written with such specificity that they only apply to certain entities, right? You look at our human rights law and it defines things like who is an employer who cannot discriminate in employment. And there are limitations on how many employees are part of that, so there's like a limited definition of what an employer is, what a public accommodation is, which is something like a business that's open to all comers or a hospital that provides public assistance. And there are things that fall through the cracks sometimes, or defendants who might argue that they're not covered by our state's human rights law. And sometimes those are government entities. We have brought lawsuits against OTDA, right? The Office of Temporary and Disability Assistance, the state agency that is in charge of providing, among other things, benefits, access to medical care for people across the state. And they have argued that as an agency, they are not subject to the human rights law, that they are not a public accommodation, and they are not an employer, and they are not a housing accommodation. And therefore, those more robust protections maybe don't apply to them. These are arguments that they often lose because we think they're wrong. But having an equal rights amendment that makes it abundantly clear that every government actor, every government agency, every municipality has to follow the same anti-discrimination laws is a really powerful thing. OTDA would not be able to argue that the ERA doesn't apply to it, for example. Public agencies providing benefits directly to people, the HRA, these are agencies that would not be able to make those types of arguments. And so it would, again, sort of just provide another tool that ensures people's access to their rights is a little bit more robust.
Thank you. I will ask again, are there any other questions or comments?
I just had a quick thing. Just this is about the mask mandate. There was a email that went out today about signing on to a national letter and a New York state letter. So I just wanted to make sure that you got that at BCID because we just got it this
I
afternoon.
didn't see that, but I will
Yeah.
look that up because that's a
Okay.
good thing. That's a good thing.
Yeah, if you didn't get it,
involved
let
with.
me know and I can
Just
forward it.
send it. Why don't you just send it on? We didn't see it.
Okay.
And we had
Okay.
actually, Evan had written a letter that we didn't finish. So that's good that there's
Yeah, there's a letter that they've
going around.
done on
Good.
the national and state level. So, and they're
Okay.
still working on it. One's due on November 15th, the national one to sign on, and the state one, they haven't picked a date yet because I wrote an email to them and they said they're still
Okay.
deciding.
No,
So,
let's get that. That would be great.
okay.
Um,
And thank you. Sorry.
yeah, good.
Okay, any last questions or comments?
Please tell your friends about Proposition 1 and make a plan to vote if you have not done so. Early voting is from 8 to 8 until this Friday, and then from 8 to 5 on the weekend. And then on Monday, there's no voting. And then, of course, on Tuesday, the polls are open from 6 to 9 in New York State, 6 a.m. to 9 p.m. And it probably makes sense to go and vote early because the lines will undoubtedly be long for people who, people like to vote on the day. And in fact, that was what I always did until this time around. So I really encourage you to get out and make sure your friends vote and vote yes on Proposition 1. Thanks so much, Bobby and Evan
Yeah,
Thank you all so much
so
for having me.
and
yeah,
interpreters.
we'll just give a big thank you to Bobby for coming very, very last minute, but we knew this was necessary. And so we, hope it helps people tonight and also that all of us can share the video to everyone who registered tonight. I'll send you a link to the YouTube video as soon as it's up so you can share it with your networks. I'll just remind people again who are here and watching on YouTube, if you're interested in helping phone banking to make sure people with disabilities have a plan to vote and also that they have information about Prop 1, you can reach out to myself, Evan Yankee. My email is in the chat again and will also be in the YouTube video description and I can set you up. We are talking to people about Proposition 1, but there's a lot of people with disabilities who are already planning to vote on Prop 1, but may need help making a plan to vote. There's a lot of barriers to voting, whether it's Access-a-Ride, subway elevators, scheduling staff, all those things that making a phone call to someone can really help with. So we're going to keep trying to do that. But yeah, thank you. Big thank you again to Bobby, who really gave us a ton of great information tonight. And I hope it inspires us to all go out and promote this proposition and making sure people with disabilities vote. So thank you everyone for coming tonight and thank you, Bobby.
One last thing is just to remember, if you're voting on the paper ballot, it's on the reverse side. The Proposition 1 is on the reverse side of your ballot. There are some city propositions we're not going to go into here, but you have to turn over the paper to vote. So remember to do that. Thanks.
Thanks, everyone. Have a
Oh,
great
and
night.
thanks to our interpreters as well. I'm going to end the
Thank you to
meeting,
the
but
interpreters.
if you have any other questions, please reach out. But it was good to see you all tonight. All right. Good night.